Alright, the purpose of this training video is to outline some of the employment laws, the most relevant employment laws that a firm or organization must be aware of when conducting business and how it relates to its employees. Now, managers and supervisors need to understand these laws in order to prevent potential liabilities from being opened up, which can be very prohibitive in terms of their cost and as well as the effect on production that non-compliance can have. The first of these laws, that's probably one of the most important, is the Title VII of the Civil Rights Act of 1964. And now, the Civil Rights Act of 1964 that was established to provide injunctive relief against discrimination in public accommodations. It authorizes the Attorney General to pursue suits to protect the rights of employees, and it extends the Commission on Civil Rights and establishes the Commission on Equal Employment Opportunity, or the EEOC. Now, employees have the right to consideration of employment and to operate in an environment of employment that is free from discrimination. Employees cannot be discriminated against for hiring or for promotional purposes on the basis of race, on the basis of sex, gender, religion, age, etc. And this Title VII of the Civil Rights Act provides an avenue for employees to take to file grievances and suits, which can be filed with the Equal Employment Opportunity Commission, and they also have the right to file civil suits as well. So it's extremely important that managers, supervisors understand this particular law and the fact that discrimination carries with it potential liabilities that can put the organization not only in a financially difficult situation, but also from a public opinion perspective. So very important to remember this. The next law is the Fair Labor Standards Act, or FLSA, and this law establishes the minimum wage, overtime record keeping, youth employment standards, and then this is in both public and private sectors. And it really was implemented to ensure the well-being of employees, as well as to promote the interest of well-being of employees, and ensure that they're working in a humane and ethical condition. Prior to this law, during the industrial age, when big industry began to take off, employees worked in extremely terrible conditions. They had extremely long work days, work weeks. There wasn't any recourse for them if they got injured, and so because of this and because of petitioning by union bodies, standards came about to ensure that employees worked in safe and humane environments. There are consequences for violating this Fair Labor Standards Act in regards to incorrectly paying minimum wage or overtime. An employer will be required to provide back pay for any compensation owed, and the law also allows for that organization to receive punitive fines and liquidated damages. So there's a penalty included with the back pay. So it's very important. Not complying with this law and not making sure that employees are classed correctly and paid correctly can open an organization up to extremely punitive financial measures, in addition to having to make back pay and other restitutive acts. The Family Medical Leave Act, or FMLA, provides employees who meet certain criterion 12 weeks of unpaid job-protected leave per year, and applies to agencies and companies with 50 or more employees. Now, some reasons why employees may use FMLA are to care for a newborn child, a family member, or themselves if they're unable to work. And employees who have an FMLA case do have the right to return to the position that they left prior to taking leave. So it's important that if an employee has an FMLA case open, that the employer make sure to respect that case, that they get up to 12 weeks of unpaid job protected leave. So no act that may be considered retributive in nature, meaning where the employer takes retribution against an employee for taking time off, for this case, won't be tolerated, and the employer may be liable for damages and other punitive measures if FMLA is not complied with. The last law is the American with Disability Act, or ADA, and this prohibits employers from discriminating for qualified persons with disabilities during the application, hiring, firing, advancement processes, as well as in regards to a compensation and other employment conditions. And it sets forth guidelines for the employers to follow in regards to adapting a workplace to enable employees with disabilities or persons with disabilities the ability to perform their functions. These reasonable accommodations are such that the employer adjusts that employee's workplace or their schedule, break schedules and such, to accommodate their disability, and that such accommodation is reasonable, meaning the employer doesn't have to do away with jobs and duties of that role. The employee is expected to perform those duties and those functions, but the employer is obligated to provide them with what they need in order to perform those functions. Failure to comply with this can result in punitive measures taken against the employer, civil suits filed by the employee themselves, as well as it may damage the organization's public image and brand itself. So that is all for this presentation. I hope it was informative. Thank you.